right, welcome to the House Judiciary Committee this Friday morning, February 20th, in the face of a huge snowstorm. So we're going to rush through everything today. No, we're not going to rush. We're going to Chris all the time he needs. So Chris, if you could join us, we're going to continue our testimony on H385 and appreciate you being flexible and being able to be here this morning. So I'll turn it over to you.
Good. Thank you, Mr. Chairman. I appreciate your flexibility in giving me some additional time and certainly want to get you out of there before the storm. So for the record, Chris Delia, President, Vermont Bankers Association. I want to begin my testimony by saying that all along, since this issue has been brought to our attention, we've been very consistent that we absolutely want to find a solution to the victims of coerced debt, especially when they're in situations where there is the threat or actual violence. And any responses that we've provided to your Commerce Committee up until now have all been designed to put additional guardrails around a very new program. None of those guardrails would in any way limit a debtor from raising a claim of coerced debt. And listening to your conversations yesterday, we also understand completely the concern of the perpetrator's identity being known and how that might in some way create additional harm for the debtor and the debtor's family. So we are very sensitive to those types of issues. But the challenge we face is if this isn't done correctly with the guardrails that we have sought in Commerce, our concern is there could be considerable fraud out there. People will try and take advantage of this. We are not concerned about legitimate claims of coerced debt and trying to find a solution for those individuals. So let me go through where we're at and how it relates to you folks in Judiciary. So when you look at the bill, once the debtor claims coerced debt and files the appropriate documentation with the creditor, their responsibilities, if you will, end at that point. And everything shifts to the creditor who has now received the information. And the creditor has to go through that information, and if they agree, fine. If they don't agree, the creditor has a burden of proof. The creditor will see monetary losses that will accumulate over time. And there's a liability if we don't do it correctly or misstep under the statute. And then ultimately, we will step back and say, what's the impact in the marketplace? Because we are going to have to adjust our practices in the market while still adhering to fair lending practices. So what's on our minds as far as Judiciary is concerned? You had some conversation yesterday, and I welcome additional conversation and thoughts, and I'm happy to share some documentation with you about who has the burden of proof in these cases. Is it the debtor who files the information, or does it all rest on the shoulders of the creditor to disprove a claim of coerced debt? And then the parties, if they end up in court, we believe in 4 other states in their approach would agree that it should be the debtor that proves the claim of coerced debt. We did early on in our review look at language from other states that would have required the debtor to go and get a court order first. We did not push that in our conversations here because we were sensitive to what the interested parties were saying about the difficulty of a debtor being able to do that. So when I say burden of proof, we're talking about later on in the process. The second thing is if a debtor and a perpetrator have already been involved in a court case and there's a judgment issued regarding coerced debt, we would like to make sure that this bill lines up with that process, if you will. It's already been addressed by the courts. We would question why they would be coming to us to raise a claim of coerced debt at that point. So if a court has already dealt with the issue of coerced debt, then we would question why they would be coming to us to raise the same issue. The third item is.
Can you explain that again? I'm not sure I followed that part.
Sure. So if a court has already answered the question of coerced debt and has already dealt with that in their court decision and review of the evidence that was presented, we would not want the debtor to have an ability to come to us and raise the issue of coerced debt if it's already been settled by a court.
Okay, so is that captured on page 2, line 14 to 16? That's where was not subject to either a default judgment or to a final judgment?
Yes, that was the intent of that language. And if we need to eliminate the redundancy of default judgment and just say final judgment, I think you folks had a brief conversation about that yesterday. That would be fine.
But that addresses your concern.
Yes,
I want to make sure. That one does. Okay, all right. So keeping track, you're still concerned about the preponderance of the evidence part, but Angela has a question.
It's just about that in particular. I can save it if you.
No, go ahead and ask some stuff on
Okay.
that issue right now.
Okay. Good morning, Chris. So I just want to make sure I understand when you say dealt with, or answered the question of, if a court has already answered the question of coerced debt or adjudicated the issue of coerced debt. Is the assumption built in there that that the adjudication would involve more than just like an affirmation that it was coerced debt or that it was not, but also includes the resulting financial aspect, and like that the court order says who is going to cover that debt? Is that the assumption?
No, it's not the assumption, because I learned a long time ago from a former judge who worked with your committee very closely that courts have different views and different opinions. So it's not the assumption. We were saying that if it's already dealt with coerced debt, and if the party could provide to us a copy of the court report, and if the court report says that they've already dealt with coerced debt, they've already dealt with remedies or whatever it is to satisfy the debtor, then it would seem to resolve the issue. Why would you be coming to the creditor? If it hasn't, if it's only, if you will, looked at coerced debt, but not issued an opinion or a ruling in that area, then we would not argue against the debtor coming to us.
Okay. Okay, that's what I was wondering. So I just wonder if the language says that.
I think it does. That's it.
We can talk about, adjudicated, you think it does?
Yeah, I mean, you already adjudicated the issue. Yeah, that means they addressed the issue.
Does that mean they've addressed it fully? And does every adjudication of coerced debt include as Chris said, a remedy, like an adjudication that like the victim of coerced debt is not going to be responsible for the debt? Would that be the adjudication? That's what I'm trying to understand, what the adjudication would be. Because I don't want to say just because it was brought up in court, as Chris just said, like if it's brought up in court, it's like, yeah, you are the victim of coerced debt. We have, the court says,
yeah,
you're a victim of coerced debt, but says nothing about what happens next.
Right.
Then it's the statement of the Bankers Association that since it was adjudicated, the creditor, the debtor, I'm sorry, cannot come and claim coerced debt with the bank.
So, not to dive too deeply into this, but there could be, so it's adjudicated, it's dealt with in some manner, and the creditor who's the subject of the coerced debt doesn't think it's fully taken care of. Are they barred from going ahead and pressing? Probably it doesn't fit into here anymore, but the question would be whether their claims are entirely precluded, which gets into a whole area of law of claim preclusion, of whether they can proceed with a claim that it didn't fully satisfy them. I don't know if that made sense, but it's like, it's really hard to, I don't know how you would say, I don't know how you would structure language to be able to address what your concern is. I mean, we can think about it more, but, yeah, Ian.
I think the only other thing I'm just thinking about is like in like practice.
What are we getting lawyer on you here? So go ahead, Ian, please.
I just don't know what adjudication on the merits in a court proceeding on course debt is going to be other than the civil hearing that we're talking about. Like, you know, I don't think in a divorce case, there's going to be, maybe there could be, but I don't.
Yeah, would you
Know what I
know
mean?
that if there's the finding, of course, that they're gonna make the creditor continue to pay that debt,
Yes.
The debtor,
the debtor.
right?
Yeah.
Okay, that's,
Keep
I
on
guess that was my question.
Yeah.
So let's proceed, Chris. Thank you.
Okay, so the third item, and you folks had an interesting discussion about this yesterday, and this is, if you will, the only area where we can find any relief, if you will, from the course debt and potential losses. And that's the ability to go after the perpetrator. And we have to keep in mind, we're not just talking about credit card debt, we're talking about secured debt. So it could be an auto loan, it could be an ATV, it could be a boat, whatever, anything that's outside of the scope of the bill. And we've been noodling around and trying to understand with little luck that if, and I guess I'll just use an example. If Chris D'Elia coerces his wife to sign all of the documentation and take out the loan or take out the credit card, she is the debtor. I may not show up on any of that documentation as the perpetrator. I'm not part of any contract, perhaps, that was signed. And if that's the case, we want to understand and preserve in Vermont statute, either existing or in this bill, the ability to go after a perpetrator who forced the debtor to take out the debt. And again, this is somebody who may not be part of an application, may not be part of a contract document that was signed at the end of the day. You then had a conversation yesterday about who that perpetrator is. We are sensitive to the fact and do not want to put a debtor in the position of having to reveal a name that may create a problem for them from a physical point of view or a family member. We understand that. But this all our ability to go after the perpetrator relies on finding out who that individual is. And again, we will respect what's created in the bill as far as not forcing anybody to do it, to reveal that individual's name. But we also want to preserve our ability to go after that perpetrator for the actions that they have created for the debtor and for falsely getting a loan or getting a credit card from a creditor. And then the final one
Well,
is,
before you move on to that one,
Sure.
let's talk about that. Just so first, on kind of the first concern, I'm looking at page 15, line 17 to 19, and it seems plenty broad that the perpetrator does not have to be named on the contract and documents. And that if this is the perpetrator who caused the course debt, they could the creditor could seek compensation from that debtor. So it's from that perpetrator. So that first part of what you said, I don't think is a problem here. And I guess the second part is the revealing of the perpetrator's name. And from what I understood from our conversation yesterday with the judge, if the judge or the judge's order that is in subsection C, it's on page 15 to 16, yeah, that order is essentially saying that the victim doesn't have to provide the perpetrator name. it doesn't bind the debtor or the creditor, geez, I'm having trouble creditor, the creditor from independently. And I know that's a concern, but current law or this current bill doesn't seem to prevent the creditor from on its own trying to find the perpetrator and trying to take action against the perpetrator. That's kind of how I understood what Judge Zoning said yesterday. Is that your understanding?
After listening to the judge, yes, and that's why we're here in the Judiciary Committee, just to make sure that that is clear. And I would agree with you regarding the judge's comments yesterday.
I know that folks in here have an issue, but I don't know how we could have the court actually order the creditor not to pursue the perpetrator.
When it expressly gives a right.
Then Angela.
Thank you. Chris, so one of your concerns is that you would like to know who the perpetrator is? So you can go after, so you can go after your money, basically.
Correct.
Okay. So, and I understand wanting to protect the victim. I don't have a problem protecting victims, but, and this isn't necessarily for you, Chris, but going through the process, if a victim comes forward and has been coerced into a loan, doesn't the perpetrator at that point, once a court case starts or an investigation or whatever, doesn't the perpetrator know that the victim has brought their name forward at that point?
No, because the debtor is not required to provide the perpetrator's name. And if the perpetrator does not show up on any of the documentation that was received by the creditor, we would not know who the perpetrator is.
So it goes through my mind, how can you prove that something was done if you don't have a person that did it?
Well, interesting question. We can't prove
Not you necessarily, I'm just saying the legal system. I mean, to me, how can you make a determination without a body? That's what's going through my mind. And so again, not necessarily for you, Chris, but so when this starts, there's no time at all when the perpetrator is notified that there's going to be some kind of a claim against them or case against them.
Well, if you don't know who the perpetrator is, then I guess my answer would be no. If it's a joint account, I think and I have to, no, I'm sorry, if it's not a joint account, if there are two people that have signed the documentation, if you will, that was presented to the creditor, then at least we have another name. Can we jump to a conclusion that they were the perpetrator? I would doubt it, but at least at that point we do have a name. And then again, you also have the concern that if there's communication, is there with that second party, does that in any way create potential harm for the debtor?
Yeah, again, what's going through my mind, if somebody breaks into my house and I report it and I know who it is, but I'm not going to tell you who it is. I mean,
yeah, it's a
no
problem.
common sense involved in that at all, in my opinion. But
So just a couple comments real quick relative to that. My understanding, and again, we have Charlie correct this, is that whole process of having the adequate documentation in the statement is what's supposed to build that case.
right, against who?
Against, well, that's against the perpetrator, but against the fact they have a course that. Well, I mean, we'd have to.
Nobody knows who the perpetrator is.
Well, supposedly the plaintiff knows, the debtor does.
Yep, no, the debtor doesn't know who it is.
No, the creditor doesn't.
The creditor doesn't.
The debtor
The
being,
victim.
The victim debtor.
right. And I knew who broke into my house too, but there's not gonna be anybody going to going to court. I'm not gonna say who it is.
Right, so I guess I would suggest that we just look again at the definition of adequate documentation. We can do that offline, but and the definition of, where's the other definition? Where's the other definition of storm? The statement of course debt, which is on page 4 and 5, and that's what's supposed to establish it. And we can look at it and say, well, is that enough for a prima facie case if the perpetrator is not named? That's the point of this is to get at that.
I know.
So the second thing, just as I was trying to understand, your first comment was that if this case is brought, wouldn't the perpetrator probably know about this, or is it brought anonymously? I mean, is the name of the debtor victim in the case? And my point only is if the case is out there, is the perpetrator going to know that case has been brought, and do we have the same concerns about, I mean, we have the concerns about victim safety, but have we already compromised that by the fact that the case has been brought? Yeah, that's why I thought that part of what you're saying. Now, have we already compromised that by the fact that the case is out there with the victim debtor's name? So in any event, I mean, that's something to think about, but do you have more on? So yeah, go to Angela and then Ian.
So, well, I'll ask my question. Chris, I was wondering if you can say a little bit, because I'm sure you can surmise from yesterday's conversations that I am one, or I don't know if I'm the only, but when we talk about people in the room who have concerns about this portion, it's me. So I just, maybe you can allay some of my concerns if you feel confident or comfortable enough speaking on behalf of the Bankers Association about like what might be the thought process that goes into a decision of whether or not to pursue the identity, first discovering the identity of the perpetrator, and then pursuing a collection of the debt.
I will try and do my best. That is a big underlying problem. Again, I'll start with the perpetrator who created this situation is the only one that we would want to go after to remedy this. The situation allows a debtor to file certain information with us. We will look at that information and we will, based on what's provided, draw a conclusion that we agree or disagree. And then, but the challenge becomes, if you don't know who the perpetrator is, then what there are no steps to take at that point. We don't know who they are. We're not going to speculate and run the risk of targeting the wrong person. The only way we might know something is we might know a name, but again, we may not be able to draw the conclusion that they are the perpetrator, is if we have in the debtor's file other information involving other credit that was provided to them where somebody's name showed up. But that is a huge leap to go from that person's name with the debtor to saying you're the perpetrator. And I don't think banks are going to go down that road. I think somebody said, are we going to be Googling people yesterday? And no, we're not going to be Googling people, but we want to preserve our ability to go after a perpetrator if at some point along the way, because this is somewhat open-ended with a time frame, if at some point along the way we know who that individual is or it comes to light, then we would want the ability to be able to go after that individual. They're the ones that created the fraud. They created the loss. The perpetrator, the debtor's been taken care of because they no longer owe the debt and their credit report is fixed. So when I said earlier, all of this shifts to us at this point, I feel we have a right to try and recover our losses because to Representative Burditt's question yesterday, what did we do wrong in this process? We did absolutely nothing wrong as a financial institution aside from provide credit to somebody, credit that was not known to us, that was coerced debt.
Right. Yeah, I wonder if the Bankers Association, if you don't already, maybe you can contribute to prevention efforts.
Well,
Abuse
excuse me,
prevention.
Representative, but we also, we do already.
Good.
So you know
Great.
that all of the IALTA funds that go to the Vermont Bar Foundation are used in two ways. One to fund legal aid and one to fund their grant program. So we already do that, Representative.
I wasn't implying that you don't, just that's great to know, because we're all part of this culture, we're all part of the society, we're all functioning. The victims didn't do anything wrong either. And so it's a tough position to be in. I respect that. And it's tough that we're all in this room doing all of this for, a number of people who do horrible things, and we're trying to mitigate the fallout from that. So we are all in that position right now.
We agree with you that the victim did nothing wrong as we did nothing wrong. And we're trying to find a balance in this whole process to make sure the victim's taken care of, but that we have some rights as well.
Ian and then Karen, did you have any? Yeah.
I was just gonna say one more thing,
Well,
just a reframe though about, I wonder, is it accurate to say that this isn't a claim against the perpetrator? It's really a claim like more in favor of the victim debtor? If that reframe helps, because it's not like a traditional process where it's like Tom is saying, like when someone breaks into your house and you know who it was, it's almost like like you're seeking relief without naming the person, because you're not going after that person. You're just going after, like, you're seeking relief from the debt. So it's not quite the same as going.
But there's still not
right.
being debt, then there should still be
Right.
recourse for the creditor.
Yes, and I guess I'm setting that aside just to like reframe what this is, and that it's not a traditional,
No,
you did something wrong and I'm going after you. It's more like someone did something wrong. And now we have these like relatively innocent parties who have to figure out what the remedy is.
Right.
Sometimes without going after that perpetrator, because that would cause potentially more harm. So it is complicated for sure.
and the one thing that I'm gonna look at a little bit further and we'll take from saying potentially cause harm. I think needs to be a higher standard than potentially cause harm to withhold the perpetrator's name. And I'd even look at page 60, I'm looking at line 5, reasonably likely to result, is the term reasonably appropriate there? Does there need to be a bit of a higher standard to withhold the perpetrator's name? In other words, likely to result. Right? We have that in RFAs. We don't say reasonably likely. We have likely to result in abuse. So we can look at that. Maybe that helps. I don't know if that helps, Chris. If we're looking at that as trying to have a little bit higher bar for withholding the perpetrator's name.
I'm open to suggestions, and we're happy to work with the committee on any language that you want to develop over time.
Chris, yeah, I had another thought sort of on the same. Well, so I think one thing the committee is going to have to sort of tackle is like, can you establish a prima facie case without disclosing the perpetrator? And that's like just a question to consider based on the other documentation that's proposed in the bill. The other thing, and I think it kind of goes down Martin's line of thinking, would be I kind of would like the idea, and I'd be curious your thoughts on if it was just a little bit more structured. So you have a hearing, the court establishes that it is coerced debt. The default is perpetrator is a disclosable piece of information that the creditor gets to know. On a motion by creditor or by debtor, the victim, they can request the court basically not allow the disclosure of that information. Then there's a weighing of the facts and a determination by the court, and then one way or the other. But that way, both the creditor and the debtor get an opportunity to sort of have this have the court make a determination based on weighing of the the needs of the creditor based on like the amount of the debt and like what it is and who the perpetrator may be and the debtor on the risk of harm. And that kind of shifts it a little bit from where it is right now, where it's kind of like it's almost like there's not any kind of active action that the debtor has to take to keep the information confidential.
Can I ask, Representative, are you speaking of a potential court hearing early in the process or later in the process? As
Well,
outlined in the bill.
Yeah, I think it's one question is, do you need it? Do you need to have that information, the information of the perpetrator to establish the prima facie case? I think that's like currently we don't. We have here we don't. So I guess that's like a question. If we land on we still don't need that, then I would say it would be after there's a determination that it is coerced debt. I think that's where I would see that happening. So basically, the court makes a determination, this is coerced debt. Okay, creditor, you now have a right of action against the perpetrator. Now, here's the moment debtor can say, Your Honor, I want to keep this, I want to keep that information confident. I don't want to have to disclose that information because, I think it's going to be a risk to me. Now that's been, made, and now there's an opportunity for both sides to weigh, make their case for why it should be or shouldn't be.
Right.
That's helpful. I would say, Representative, that we would certainly have comfort in a court process, in a court weighing the issues that are involved between debtor, creditor, and perpetrator. We would be fine with a court process, which I think is allowed under the bill at some point. And we would abide by whatever judge's decision. I could tell you if, and I'm not asking for this, but I'm just using it as an example. If this were all front loaded with the debtor going to court and the court rendering a decision, we would abide by that decision without question.
So,
Like at the beginning.
so let me ask, is this issue as far as the identity of the perpetrator, does that in any way relate to the burden as far as the preponderance of the evidence and who has the burden initially? Or are those two separate issues?
And you're getting a bit beyond my pay grade as far as legal processes are concerned, but
Well, no, I'm just wondering if it was the debtor who had the burden, instead of just the prima facie case, but had the burden to prove the course debt and is able to then prove that, does that make it easier to say that they shouldn't have to turn over the perpetrator's name? I don't know if that makes sense. They may be unrelated.
Yeah,
Well,
I see what you're trying to accomplish. However, the ability to go after the perpetrator, it makes it easier to address the decision of coerced debt or not.
Yeah.
What it doesn't do is it doesn't help us to go after where's the car, where's the loan money that you took out, where's the ATV, and to try and recover funds or assets that minimize the losses that the creditor is going to have to absorb.
Right, okay. All right, so yeah, no, it's an idea just throw, but I'd like, we can follow up on witnesses as well and some other content, but Karen and then.
Yes. Thank you. So continuing this conversation, because I appreciate the tension that we're trying to navigate and find a middle ground. And so my question, and maybe this was covered yesterday, and I apologize, is my understanding we're not the first to explore coerced debt here in Vermont, that there are other laws across the US. So I'm curious how other states have navigated this, or is Vermont alone in trying to find this specific line? And that might be something we can do more research with, or the network might have more information, but I just feel like this has been done before, but is it different that we're trying to walk this line with protecting the identity?
Yeah, okay. So that's a specific question that I would like to go back and look at those states as to how they dealt with the specific question. I would be able to answer it in broader terms as far as how a handful of states have not shifted the burden onto the creditors. The burden rests with the debtors. We have states like I think it's Illinois and Texas who took a different path. So there are certainly different state statutes that are now in play. I think Maine is the only one that's been out there since 2019. The rest are relatively new, that we can certainly look at to try and answer your question. And I'm happy to try and do that over the weekend.
Okay, I just feel like that'd be helpful because we don't need to reinvent the wheel. But like if there's something out there that is working, maybe we can find a better solution, but let's at least look at what's already out there. So I appreciate that. And I feel like for the network, maybe you have ideas as well. Or maybe we're exploring new territory and we got to figure it out.
Yeah, it came up a little bit yesterday, though. That's kind of.
Kind of an open question for anybody. Do relief from abuse orders work? I would say for the most part, yes. And where I'm going with it is, okay, next question is when there's a relief from abuse order issued is perpetrator, are they notified who initiated the RFA? Yeah, okay. So that's almost like a double danger in some ways. I'm sure they're already in danger. RFA, some people, it's gonna elevate what they're going through. But where I'm going with it is, so we want to protect the victims. There's no doubt about that. So is there any way that if the perpetrators, if it's decided the perpetrator's name is put out there, so financial institutions can justly get what's theirs, can at the same time a relief from abuse order be issued because they do work. Nobody said they don't work, and to protect the victim. Food for thought. Or something along that line.
Yeah, along those lines, I mean, I'm wondering if this whole process is something that only can start after a relief from abuse order has been issued, because then you have those protections in place.
Right.
No, it's
Yeah,
just
no,
because somewhere in here, there has to be proof that there is the abuse, Brett, as well. That, I mean, we're talking about, that underlies this, is that they have to determine that abuse has occurred.
and another thing that goes through my mind, if something like this is happening, probably not the greatest relationship in the world to start. And there's probably a lot of them that at some point have already had RFAs. I'm gonna guess a high percentage. That's just a guess.
Yeah, easier if there is, but,
Right.
yeah.
And I think it's important to, I think we heard yesterday that some of these cases are not like intimate partner relationships, they're foster children who are, they're being financially coerced into significant debt by foster families and, other folks who are caring for them. And they may only learn of it when they check their credit. Who knows if after they turn 18 or something, so it is hard to. And I think, and we heard testimony that how important it is to have a process that does to cover coerced debt that doesn't require first, a court order like an RFA or something. Yeah.
Would coercing somebody into signing for a loan qualify as abuse?
I think it does. I mean, under.
Yes.
There's coercion. So.
And it may be the only abuse, like it wouldn't necessarily be accompanied by physical abuse or.
So RFAs work in that.
Yeah, so I think on that, we're giving Charlie a lot of food for thought over the weekend to come back next week on that. I know we have another point that Chris wants to make. I'm not gonna put Charlie on the spot right now. I can think through and talk through some of these things that we've talked about. But I think it's legitimate to look into that as well. But I also understand what you're saying. This doesn't just cover that. Chris, I think you had one more.
Well, no, I'll just summarize very quickly. So just listening to your conversation yesterday, a few questions I wanted to respond to. Representative Burt had asked the question of credit reports, and Vermont does allow for a freeze and unfreezing of credit reports. We did that quite a while ago, just for your knowledge. There was a question about the focus seemed to be on physical abuse, and I think this was answered in your discussion yesterday, but on page 2, line 12, there's language in there that obviously goes beyond physical abuse. There's a question yesterday about valid report. And I think
Page 1, I think.
yeah, there's a question on the word valid, I guess. A report's a report. I would think it'd be a valid report. So I leave it to you. The other thing that I thought was interesting was the comment raised by Judge Zoning about the qualified third party could involve brother, sister, etc. And we would ask for your consideration that it is an independent third party that is aware of the circumstances, has worked with the debtor, and not somebody who may have potential conflict because they want to obviously support their loved one.
Yeah,
So
we do have legislative counsel looking into language for that.
Yeah.
So,
Other than that, Mr. Chairman, committee members, I really appreciate the opportunity to spend time with you this morning and have this back and forth give and take. These are critical issues for us and for the debtors, and we just want to make sure that we have a bill that can work for the parties involved. So I hope to be there next week and happy to look over the weekend at what other states have done to answer the question of the perpetrator. But again, just thank you for your time today.
I appreciate it as well, Chris. And by the way, very nice sweater. Is that like a Norwegian sweater? I'm a big fan. I can't help it. I mean, I have a sweater that looks very much like that my Norwegian aunt knit for me. So
Yeah, it is from Denmark.
oh, the Danes, I tell you.
Yeah, the Danes.
They're trying to copy the Norwegians. Yeah, they're trying to copy the Norwegians. Thanks a lot, Chris. Have a really good weekend, and
Thank you,
we'll
folks.
be talking again next week.
Thank you, Chris.
Thank you, Chris.
All
Okay.
right, so we're gonna move on to budget discussion.
Can we take like 2 minutes to say hello to our former member over there?
Yeah, actually, if we could have introductions of the folks that came in and let them know who's sitting in.
Absolutely.
Kate Wolf from Northeast Kingdom here for the ACLU Bobby Day.
Okay, excellent.
Jessica Neary also from the NEK for the same reason.
Okay,
Winnie Wilkinson for the ACLU Lobby Day.
excellent.
Kathy Vance from Danville, ACLU.
Great.
Welcome.
Who's this guy in the corner
I
here?
don't know. I think you should get in the hot seat.
Former representative from Rutland City who just had a reminder of how boring some of this work is.
In the hot seat when it says that.
He's on up. He's putting himself in the hot seat.
Please, I tell you, that's terrible. That
Now,
was
for
some of
the
the more
new-
exciting stuff we were doing.
Yeah, for the new members, there's two here. Will is a former representative from Rutland City.
And I came in the same year together and served in this committee for 6 years.
Don't remind me.
And I'm off now and doing my own thing, and he's still a career politician.
And continuing the work that you were doing here in a way.
Yes. Yeah, for those of you who don't know, even for career politicians, there is, I'm saying, life and gainful employment after the Judiciary Committee. I am the Justice and Belonging Coordinator at the Rutland County Restorative Justice Center. And I watched Karen walk us through some legislation when I was here on restorative justice. And so it made me at least qualified enough to put a resume together. And I've said to a few people since I've been, when I've been back today, I feel like I spent 6 years here doing the hypotheticals. And it feels really good to be on the ground doing the actual work.
Ouch.
So real quick, and Will knows that the story I'm gonna tell. Yeah. The
You win
first
this one
day,
now, you win.
yeah, so I'm from Rutland City, live in West Rutland. Of course, Will is Rutland City. I always knew who he was because of Board of Aldermen and all that. He knew who I was because of up here, but we had never met, but he knew my daughter. First day he walks in, he says, "It's really nice to meet your daughter's second favorite politician." And the zing for 40 years, going back and forth, never stopped.
It's good to have you back, Will.
It was lovely to see everyone. I'm gonna go home now because I remembered how terrible the drive is from Rutland, and I'm gonna try and beat the snow, and Representative Burdick, good luck to you doing the same.
Yeah, we're gonna
The
try
rest
to
of you who have long drives,
appreciate it. Good to
thank
see
you
you.
all. All kidding aside, I know what good work this committee does.
Thank you, Will.
And I'm seeing the good work on the ground that this committee has worked on for years, so thank you all.
Thank you, Will. Good to see you.
Good to see you, man.
Don't be a stranger.
No, the problem.
Hey, Will, good to see you, man. Okay, so we're gonna.
But it's almost nice to see
All right, so we're gonna turn and see how far we can get on the budget memo today. We're gonna skip the network against domestic and sexual violence and the Vermont Center for Crime Victim Services until Jen Holman becomes available. So kind of watch for, I think she's gonna try to log on at some point. Maybe just okay, well, maybe we'll turn to that right away.
When is Jen coming in?
Possibly, can you say that she's on now? No, she's.
I let her in, but I don't see her up here.
Okay, all right, well, we'll wait. So just walking through, I highlighted, having learned that from legislative council, the changes from when we last looked at this. And just kind of walking through this Office of Defender General, I reached out to Matt Valerio, and I'm happy to send his response back, but I asked him a question. I asked him whether, let me look at my question for him. I asked, of these requests, what are your priorities? If I recall right, the first three items were top priorities and the last two are less of a priority. Is that right? His response was, short answer is yes. The second two numbers are part of typical budget fantasy. 610,000 vacancy savings is unattainable. Haven't made 600,000 in a special fund in 10 years, but they just use those numbers to balance the budget. Essentially, that's why the short answer is yes. I'm not sure I understood the rest of this answer, but that's why I moved that to tier two, the last two things from tier one. But so what I'm going to do instead of trying to come up with a priority list, because we're running out of time of what's in tier one, is I'm just going to straw poll each of these to see if you agree that it should be in tier one. Does that work? Because I don't know if we're going to have enough time to debate what should be our priorities. I'm trying to figure out the best way forward on this. I have to get to it.
I'm not sure, but I do know no matter what we say or what we do, that appropriations is gonna do whatever they feel they need to. I mean, that's the way it's always
Well,
been.
that is the reality of it. But it's stuff to do with stuff.
No, I understand.
So just on
Either
the,
that or we could put it in as that's what these people are looking for.
but I think we can at least give them these are the tier one or the ones that we don't think are priority.
Yeah, I think we could go that simple.
Yeah, because I don't think we're gonna be able to come to agreement of how to rank these things in tier ones. That's my point.
I don't think, I had a conversation with Trevor last night about
Okay, but
this. Which is great. It's a great explanation in the way it's done. And in a nutshell, they do what they have to do, you know, and almost like, to me, if the letter says this is what each of these, departments or whatever are requesting, and that's just the way it is. There's no opinion. I really don't believe our opinion. It's not that it doesn't matter, but they trump a lot of budget opinions. So that's just
Yeah, I think, except I will say that if they're looking at all these various requests from these entities, one of the things that can help them decide, if they have a few $100,000 that we have said, those things are less important, and these things are the most important parts of it.
Yeah, that's our tier one. and
Yeah,
tier two.
yeah.
That's just my idea.
And then,
You've got this paper right here. I don't think we need to do anything more. It's like what Tom says, just submit it and go with it
well,
because.
I need to just agreement that you folks are fine with the way I broke it between.
I'm not, but that's okay. But I'm not gonna have anything to say about it anyway.
Well, no,
Except when I get on the floor and vote no.
all right, that's fine, but I can go on each of these and I can say, I just want a straw poll on who supports keeping this in tier one.
I mean, I think anybody could maybe take some little piece of a tier one and tier two and swap them and maybe even put something into a tier three. And we're never gonna probably get everybody to agree on it exactly. But it is a guide. And no matter what we do, if we swap something because somebody doesn't like it, well, it's gonna change the opinion of somebody else. And yeah, it's a guide for appropriations.
Make it more
I
complicated.
mean, we can get into an argument about it and say, well, I don't like, these people getting this money and those people getting that money, and I think these people should get more, and it's just gonna potentially it's gonna create animosity in the committee, I think, and I don't think we need to go through that with this. I don't think we need to say this is our recommendation. I think this is what people are asking for.
Stay out of it.
Go ahead, Karen.
I mean, I can support that piece, because I think one of the other reasons that appropriations has us look at these is to vet them in some way, to make sure that they're actually needed and justified, because there might be ones that were like, doesn't seem like that's a need at all, and that helps inform them so they don't have to consider certain ones. So I feel like that's also a lens that we're putting on this. And I think they would love it if we prioritized and, like we could all get an agreement of this is the number one thing. Like if you have $300,000, put it in this. But I agree that we're maybe not at a place to do that. But at the very least, we can let them know, like, we vetted these. These are all reasonable requests. And now you take that out.
And I guess the only thing still is, I mean, if people are fine with it, it takes us a lot of time.
Unless it changes with Jennifer.
Yeah, we do need to hear about that.
Also,
Yeah, go ahead.
I guess I just have one comment, is that the delineation between tier one and tier two, I don't want, and I totally take Representative Dolan's point of, like, we have heard from witnesses from all of these organizations that are all doing very noble work and important work in the state. But I don't want it to be interpreted as if something is in tier two and it's still on the list, that it is approved by the committee. Because there's like, for me, I mean, I certainly, I don't want to speak for others on the committee, but I have a very strong view of a couple line items in tier one that I just don't agree with.
So perhaps this is the way we put it to the appropriations. And this is the language I used the other day, is this is what we've heard from these folks that we heard from them is what they're saying they have to have. Tier two is what we're interpreting from what we've heard that it would be nice to have, but then it's along the line.
Well, I think that was more the way that you framed it, but I agree with the sentiment.
So
Like there are the essentials, and I think you and I did have a conversation about that, Chair. What's essential and what is probably unessential. I mean, I'll call a spade and kind of point out exactly what I disagree with. I really disagree with the inflationary increase under legal aid. And I think they even point this out, is that the annual 3% increase that affected state agencies was for state agencies. Legal aid is not a state agency. And so they're looking to have access to an increase in funds that was given to state agencies for the work that they're doing, and they don't fall into that category. So I think it's unreasonable for them to expect and to even ask for those additional funds. I would move to have Human Rights Commission moved into tier two. But beyond that, I think the work that the network and the courts, the Vermont Center for Crime Victim Services, I think those are all very important causes that are justifiably in tier one.
So agree with that, as far as where you are, but I would still say if we're casting this not as our opinion on these, but this is what we've heard from these entities as their must-haves. And these others, or they're saying have to have, and they also recognize they're not even gonna get everything that they
Right.
feel they have to have. And then the second thing seems to be more of very much a wish list, or however I want to put it.
So then the only thing, I take that point, the only thing that I would ask then is that the way that tier one is presented to appropriations is the different agencies are alphabetized, so it doesn't show any kind of favoritism or, I mean, if this is purely looking at what
That
is.
makes good sense. That makes good sense.
So that way, because granted, like,
Yep,
we
right,
all
yep.
have areas that we agree with more than others on this.
Yep.
So if it's alphabetized, it just looks
Good
as
point. Good point.
a unified.
Yep, absolutely. And
So
I will note
that's the way
that
it's
it's
presented, that's
alphabetized.
fine,
And I
yeah.
will also note that it's alphabetized. And
Question around, Zach said around the Human Rights Commission and vacancies and things. And again, that doesn't increase their budget though, does it? At 65,000?
well, they're essentially being asked to cut that.
Oh, okay, okay,
And,
gotcha,
and they're
Gotcha.
saying that
okay,
that's what would happen.
all right.
All right, so, so the one other part that I just want to call attention to and see if folks, and then we'll get to Jennifer Pullman, is what I added. I have some additional information from Mark Anderson that folks can take a look at. And perhaps I want to give people enough time to look at that. But the language I have here, I have a question of should we propose an increase to $65 per hour? But then again, that kind of goes against what we've been talking about as far as just laying out the priorities for these other entities. And let them sort it out. Appropriations. Tom, do you have an opinion? So, yes.
Just a clarifying question. Well, what you mean about that is not offering our solution,
Right.
that just keeping their request as
I know that
alphabetized.
appropriations wants me to do that, but I'm feeling that
But
that's.
they could have a conversation with you or others and what are your ideas? We can't do the full, what can we get to?
Yeah, I mean, so I can, as just a representative, if I can weigh in and say that I think you should do that with this and make it very clear that this is not the Judiciary Committee. And I'll make it clear in here that we're not voting on any particular priorities.
So I'm gonna guess that no matter what we did in the past, as far as, sending our letter over, that they've had questions at some point.
The appropriations?
Yeah,
Not that they've asked. Well, no, the only thing I told Robin Shy about the one.
no, I don't mean this, I mean in past years.
Have they had questions for us?
Yeah,
Yeah, they have.
yeah,
Right, so they can come and ask us after we give this. They'll say, what's your priority? They'll say,
I think the thing that you're saying with this is that we came up with a solution. We didn't with any of the others.
correct.
Yeah.
So I think I need to take that off.
Yeah.
It doesn't comply with the rest.
Can we talk about the accountability docket?
Yeah, so that's another thing that yeah, where did I add that?
what's that?
Page three.
All right, yeah. Here's another place where, is that one that I take aside and say, hey, because once again, I'm saying here that we actually support this.
On that one issue, the accountability
Yeah.
documents,
Yeah.
I wouldn't have a problem with that.
I can keep it in.
What?
Keep it in.
I would vote to keep it in, not that we're voting, but I would, and I think it's important to tie it to the conversation about pretrial supervision,
Which is in there
the
too.
way that you've done.
Yeah.
Yeah. I don't,
just call,
we could almost make it even clearer, but.
and maybe if we just call it accountability dockets, it gets to the top. I'm kidding.
No, Karen, I like
Yeah.
that, Karen.
Cut out that extension of it. I have one.
If we're alphabetizing, I like that.
I would just ask that we strike last sentence, paragraph 1 on the accountability docket. It goes, we understand the need for flexibility in the use of these funds and fully support the expansion of the accountability docket approach in Rutland and in other counties. I would just strike the in Rutland and other counties part.
Okay.
Just so it's,
I'm serious.
well,
But I think I've
Well,
always.
you understand why.
of course, no, I just think
It's Rutland.
we already said it's Rutland County and I just
Oh, okay,
and I
okay.
just sort of feel like it's better to
No,
say we
that's good.
support the expansion of it. And I don't want it to, yeah.
Wherever
We
it
get
works.
one.
Yeah, yeah.
One-
Wherever. I'll
You
take it.
get one, you get one. Is that okay?
One mention of that.
I was gonna raise my hand and suggest another mention of Rutland in there.
I second the motion.
All right, so let's try to sort out what's going on with the network, 450,000 request as it relates to the Vermont Center for Crime Victim Services. Jennifer Pullman, if you can join us and shed light, I guess one of the big questions that I had, and you can also talk a little bit further with this, obviously, is whether the $102,729 general fund supporting the grants, is that anticipated coming out of the domestic and sexual violence special fund and that $450,000 that we have in the networks ask?
No, that's a separate ask. Sorry, for the record, Jennifer Pullman, Vermont Center for Crime Victim Services. That is a separate ask from the center to go into our general fund base. We've
Okay.
been doing this work for decades and as insofar as administering, like when there was testimony that funds go to the center, they go through the center. And that is the crux of our ask, is that we're a state agency that's doing mandated work for free. And we cannot continue to do that. With the decline of special funds and federal funds, that impacts our administrative overhead. And we're just not in a place where we can continue to do that. So that is a separate ask from us. In that.
So Jennifer, if the funds go through the center and then to you, and I'm just gonna throw a number out there, $100,000. And if that $100,000 goes, has a stop before it gets to you, I gotta believe that there's gonna be administrative fees taken out of that. And the amount would be less than $100,000 going to you, but if it went directly to you, it would be the full $100,000.
Yes, we don't take anything to administer state general fund dollars that go directly to the network or to the child advocacy centers or to prosecution positions or from the DVS fund. We do not take a single dollar. Where we get our support is through the comp special fund, the restitution special fund, and federal funds. So as those decline, that means we have even less ability to, I mean, our staff didn't get COLAs or steps either. And so we need this to support increasing costs to us that we don't get to take part of because we're not state employees. So when insurances rise, when rent rises, when IT costs increase, we don't even have access to that ability to kind of collective bargain as a larger contract. So right now, this is unfunded work. That is a lot of work and a lot of grant administration. And we want this, we're requesting that this would be a separate ask in terms of our general fund base. So that $102,000 is what we're asking for. That's it. Even though special funds are in decline, we think we can do it. And we just would like the support of this committee and hopefully the state.
Thank you, Jen, for being, so you may have answered my question, but it also provides confusion for me too. And I wish we could have you and the network right here at the same time, because I feel like maybe hearing different things. Because I believe when they shared their testimony. What we heard is, and I'm sure you've seen the whole document that we're working with, right? So they have this $450,000 request. And I believe, and I have my notes, what we heard is 350,000 of that goes to the network, and there's about 100,000 that goes to Center for Crime Victim Services. But then I just heard you say that if there's money going through that special fund, it all goes to the network. So that's where I'm confused, because I'm hearing two different things. I'm sure there's a common truth there, but if you can help me find that.
I'll admit I'm confused as well, and I don't think that our ask was meant to go as an increase to the special fund. That's confusing to me, and I know it's confusing to my director of finance as to how that would work. It disadvantages us, to be honest, and that would not be we appreciate the support, but that would not be the format that we would support in terms of what would help the center. The center is asking for the $102,000 in terms of our general fund base.
Okay, would you agree then that it could be seen as the same 100,000 that is in the network's request too?
Yes, I understand that. And I think it would be cleaner from my perspective is if the network's ask was more reflective of the deficit in their fund, which I know Sarah spoke to, which is projected at, on our end, $343,000. And so that would be 350 as she's requesting, and just put the other piece into the center's base.
Okay, that's very helpful for me. I feel like that makes it very clear. Yeah.
Yeah, please go ahead.
Hi, Jen. Okay, so following on Karen's question and trying to make sure we understand this correctly. With the 450,000 one-time appropriation from last year, we learned that 200,000 was held in reserve. I don't know if this is the right term, so you'll correct me, but held in reserve by the center, and 250 was dispersed to the network for them to then share among their member organizations. Is that correct?
Yes and no. The fund was in deficit. We recommended, and we have no authority over how the network spends the dollars that we pass through. They decide it based on formulas and different things that they utilize. Our recommendation, our strong recommendation, was that with a declining special fund, that the 450 entirely should be held and not to give out increases, even though we understand why, because you're essentially increasing the obligations that are on the special fund in terms of granting. So currently, right now, with the old obligation was $783,000. The new obligation now, because there was a disbursement of $250,000, is over $1 million. So our recommendation was that it would be best to kind of restore a cash balance to the fund. We understand why that they made that choice, but it creates a challenge. So we don't have any authority. I want to be clear about that. We just do our job, and if the money is what's appropriated, we provide that. So it was our recommendation that all of it be put in the fund. They, as we understand, split that piece so that they could give some increases to their staff. And again, I completely understand that. It just creates more funding challenges because all of our special funds are not doing very well.
Okay, I think I get that. So the recommendation from the center was keep all 450,000 in the fund last year. And what ended up happening based on that recommendation, perhaps the network made the choice to keep 200 in the fund and use 250 to share, to disperse among their members.
And I understand, and that doesn't even go a long way.
Right.
Just creates, I didn't want folks to think that the center has no authority.
Okay.
folks to think that we were saying you must do this or you have to do this. It was in looking at the year's worth of declines in the funds that we felt it would be best to, have that rainy day fund. And, but again, understand the policy, that decision that they made. It just creates financially a little bit of a challenge.
Gotcha. Okay, thank you. Oh,
What?
sorry, one more. So I don't know if it's too early in your budget cycle or whatever to know this, but would you recommend, do you think your recommendation would be the same this year? That the network, is this a common recommendation to grantees or sub-grantees, to reserve, keep some money in reserve in the fund to not increase the, what did you call it? Not the burden on the fund, but
Obligations.
obligations, yeah, to not increase the obligations this year.
This is a tough one because we support so strongly the work in the field, which is why we have never taken any pieces in terms of pass-through. And something needs to change for our sub-grantees. Something needs to change because it feels really awful to say you shouldn't be giving increases to reward your staff. But in this
No,
financial,
I'm thinking, no, and I don't mean to put you in that position. I'm sort of thinking of, is it fair to think of the center as like almost like a fiduciary? That's probably, I know that's like that means a very certain thing, but yeah,
we
I
try
get
to
it.
do the best we can because we are the people responsible to the federal government and to all of you. And
Yeah,
try and give this bad news that we often have to give. It's not comfortable, but the reality, Carol's my yin to my yang. She's more like the bottom line, Jen, bottom line. And I'm like, can't we give everybody everything? I think that we don't know what's going to happen, and things are very tumultuous. And we would not be responsible stewards of funds if we felt sadly in this climate that all of these pieces should go to increases, if that makes sense. I'm
yes,
trying to walk the fine line.
I totally understand. Thank you.
Okay. Any other questions for Jen? And do we know what to do as far as what we're keeping? Are we just gonna keep in what we have for the network at this point then?
Like, it sounds like there's 100 that is in the network and also with crime victim services. So it's the same money.
I thought I understood, wait, let me see.
Yeah.
That's how I'm
was
hearing it.
coming from the network.
Yeah, so it sounds like, I don't know, like we do the 353,000 for the network and the 100. It sounds like there's stuff underneath all of this, but
Well, I guess I thought I understood that the $102,729 is not associated with $450,000, or my misunderstanding.
You are.
somebody else explain.
I think you're misunderstanding because we've heard two different things. So it's a fair misunderstanding. It sounds very possible that the network had included about 100,000 for the center administering the funds in the network's $450,000 ask. And the center included it separately in their ask. But that's,
Jennifer, go ahead. I'm sorry, she's gonna,
Okay.
I think.
Sorry. Yes, it is separate. And I think that, again, it should not be going through the DVSV fund. That's an awkward mechanism to support the center. And the center supports other general fund grants out to the community. So it really makes much more clean sense. And I understand from Sarah on multiple occasions that they were trying to support us, which I appreciate, but it really just needs to be a cleaner ask that goes to the center for overall administration of general fund dollars, which largely includes the network, but includes other programs as well.
All right, you two figure that out. Okay, you can show me the correction on the documents for that. Okay, thank you, Jen, I
Thank you.
appreciate it.
Drive home safely.
Yes, yes, we will. So,
Hope you wrap up soon.
so we're gonna go off live, because we don't have anybody until 11:30, but,